Ya estuvo.
Solo falta la cámara de la embajadora Socorro.
Lo que pasa es que yo piqué encima de mi imagen y ahí no funciona,
no.
hay que picar abajo.
Sí, abajo. Ahí
Hay que picar abajo.
Y ahí también
Sí.
se quita el mute para cuando inicie la ronda.
Joel, ya. No, ya, había que picar abajo. Sí.
Estaba haciendo lo mismo que Juan Manuel, pero ya estoy aquí.
Exacto.
Perfecto, entonces damos inicio. The International Court of Justice is now in session. President Hernández Garcia and the Honorable Judges Flores Liera and Gómez Robledo proceeding. The case before the court is a case concerning JV-18. The parties are applicant, the United Republic of Apepluya versus respondent, the democratic states of Rondas Nacionales. The applicant and the respondent are each allocated 45 minutes to present their pleadings. You have the mute on. You just have to.
Thank you very much. Good morning, everybody. I salute in the very first place to my colleague judges, Ambassador Juan Manuel Gómez Robledo and Ambassador Socorro Flores. Let me congratulate you, both teams, for coming to this final of the JSUP International Moot Court competition. On behalf of this jury, we wish you the very best in this competition. Now, I will start with the applicant for its oral arguments up to 20 minutes, and then we'll continue with the respondent. So you know the rules, so you don't need any further explanation. So I go back to you, Maria.
Applicant, will you take the floor, please?
Your Excellencies, may it please the court. Good morning, Your Excellencies. My name is Jorge Aguilar, and along with my co-agent, Ms. Liliana Ochoa, our counsel, Ms. Mariana Campos, and the rest of our team members, Ms. Abril Ramirez and Ms. Mariana Perez, we are honored to appear before the International Court of Justice in representation of the United Republic of Apepluya, the applicant in the present case. I will speak first for 22 minutes, and I'll cover issues A and B. Regarding first, whether Rondas violated international law by applying its entry regulation to Apepluya, and second, whether Rondas violated international law by refusing to hand over Ms. Kim platform. My co-agent will speak second for 21 minutes, and she'll cover issues C and D. Regarding first, whether this court has jurisdiction to entertain the counterclaim presented by Rondas, and fourth, whether Apepluya violated international law by shooting down the maintainer reserve. We respectfully reserve 2 minutes for rebuttal. Your Excellencies, if I may, I'll begin with pleading A, and I will divide this issue into two main arguments. First, Apepluya violated the dispositions contained on the international health regulations, and second, that it also violated human rights law by applying its entry regulation to Apepluya. Your Excellencies, regarding our first argument, we contend that Rondas violated the dispositions contained on Article 43 of the International Health Regulations. This, Your Excellencies, on the grounds that even though the same IHR allows a state to impose measures that go beyond the recommendations of the WHO, whenever they achieve the same or greater level of protection, Rondas did not comply with the three essential elements in order to do so under international law. These three elements, Your Excellencies, are mentioned in Article 43.2 of the IHR, which established that whenever measures are imposed, they must be in accordance with scientific principles, Second, that they must be based on scientific evidence. They must take into consideration the advice from the court. Regarding the first element, we contend that there is no way that Rondas Nacionales could have complied with the scientific principles element, since the measures that they imposed were made on a precautionary basis. And therefore, Your Excellencies, taking into consideration the jurisprudence given by the WTO, especially in its Japan Apples case, it was determined that the precautionary measures must have a direct link with the risk assessment that is made and the information that is given regarding the certain disease. Of the present case, Your Excellencies, we contend, as it is mentioned in Article 5.7 of the SPS agreement, that the precautionary principle may only be applied whenever there are no evidence regarding a disease. On the present case, Your Excellencies, we contend that since it is mentioned in the Statement of Agreed Facts in its paragraph 7, there is clear information that both states have accepted as valid regarding the COVID-19 virus. This being its basic reproduction rate being from 1.2 to 1.4, the incubation period, and the human-to-human transmission. Therefore, Your Excellencies,
may I, if I may, I'm sorry, I think you started discussing about the international health regulations, which I think it's a very important argument, but I would like if you can elaborate a little bit more about the legal nature of the international health regulations and the legally binding effects before the defendant and the applicant. If you can tell us a little bit more about that, please.
Of course, Your Excellency, we can rely that since mentioning the Statement of Agreed Facts in its paragraph 54, that both states are parties to the international health regulations. Furthermore, they are also parties to the WHO's Constitution, which establishes in its Article 21 and 22 that whenever the health regulations enter into force, they're going to be binding on the parties. Your Excellencies, we contend that since Rondas Nacionales did not comply with the scientific principles, it was not legal under international law. Furthermore, Your Excellencies, and regarding the second element, we contend that the scientific evidence element was not met by Rondas Nacionales on the present case. This, Your Excellencies, on the grounds that it is mentioned in the Australia Salmon case that the information and the measures imposed are going to be taken into consideration on a case-by-case basis. Nonetheless, it is also mentioned in the U.S. poultry case that the measures that are imposed must be necessary and suitable. Your Excellencies, we rely on Article 25 of the Articles of Responsibility of States regarding the necessary element in order with the necessity circumstance that this was not complied by Rondas Nacionales since there were other measures that they could have applied that would have been less restrictive and than other appropriate measures that could have been applied. Your Excellency, we can rely on practice of previous pandemics such as influenza and the present one of COVID-19. But there are measures imposed by states that are not as draconian as the one imposed, and that they could have achieved the same level of protection. This being, Your Excellencies, the ones mentioned by the CDC of the United States, being that there may be a limitation of international flights, the application of protective measures to shipment workers, or also, newest one entered on January of this year, being that a person that travels to another place must show that they had a negative result in their test of the virus and that they must quarantine whenever they arrive to the territory. We contend, according to several doctors, scientists on the present case, such as Gunatsotia, Kirke, and Menke, that these type of measures only affect unnecessarily the economy of other states. Therefore, Your Excellencies, we respectfully request this court to declare that the science is not met as well on the present case. Furthermore,
if I may ask you at this point, so in that case, what is the weight that you give to the obligation of the respondent to protect life and health of its population?
Your Excellency, we're contending that the protective measures that Rondas Nacionales applied were not the best ones that they could have applied, and that they went against the object and the purpose of the international health regulations, which established in its Article 2 that there may not be unnecessarily interference with traffic. Therefore, Your Excellencies, since the purpose of the World Health Organization and the international health regulations are for states to apply measures that do not interfere with this with the traffic, Rondas Nacionales did not comply with this element on the present case since it was bounded, according to the Pacta Sunt Servanda principle, to the international health regulations. Yes, Your Excellency.
Yes, if you allow me, and in connection with the previous question, did Rondas Nacionales have to strictly comply with the recommendation given by the Director General of the World Health Organization, or simply did it have to consider it as part of the guidance and advice given by the World Health Organization? And this is very much connected to the question of whether or not do you feel that the response undertook a risk assessment before making issuing the travel restrictions. In fact, and I would also like you to elaborate, what does the practice during the COVID-19 pandemic suggest if that practice had taken place at the time of the facts of the present case?
Of course, Your Excellency, regarding your first question, we do not contend that the recommendations to reconsider were binding upon Rondas Nacionales. Nonetheless, according to the Whaling in Antarctica case, by this court, it determined that it had the obligation to consider them under the principle of good faith. And Your Excellency, on the present case, it is clearly shown in its paragraph 12 of the Statement of Agreed Facts that Rondas Nacionales not only declined to follow the advice from the WHO, but also that it invited the rest of the international community to not take into consideration the advice given by the WHO. This is a clear principle, a clear establishment of the bad faith in its actions, Your Excellency. And regarding your second question, we contend that the risk assessment that was taken by Rondas Nacionales, according to the Polio's case, did not have a functional link regarding the information and the measure that was imposed. Therefore, Your Excellencies, it did not comply, or the risk assessment was not in compliance with the information given by the JVID-18. And Your Excellency, regarding to your third question, we contend that practice that goes against the rule of law is illegal under international law. This, according to the Nicaragua's judgment that mentioned that until a new rule of law surfaces, that goes against another rule of law is going to be deemed as illegal. Therefore, Your Excellencies, we respectfully request this court to declare that the international health regulations were violated by Rondas Nacionales. Your Excellency, regarding our second argument, I'm sorry, Your Excellency, were you going to ask a question? I'm afraid your microphone is off, Your Excellency.
Can you hear me now? Yes. Well, I think we are going into a very important part of the argument that is and you are talking about that precisely now. But I'm not convinced that international health regulations are fully legally binding, and I think there is an element of a practice among states, and we have seen in several cases where health issues have arisen. That countries, even if they are advised by the WHO not to apply restrictions to international travel and transport, we have seen, in fact, that many countries apply. So do you think that this has an impact on the bindingness of the international health regulations? Or can you elaborate a little bit more on the bindingness vis-a-vis the practice?
Of course, Your Excellency. We can, for example, on the final report made whenever influenza no longer was considered as a pandemic, that other states that have not complied with the international health regulations or the advice given by the World Health Organization was deemed as illegal under international law. And therefore, we request this court to judge on the present case on the same basis that the practice taken by Rondas Nacionales was not in accordance with international law. Furthermore, Your Excellencies, we contend that there's an essential element which actually leads me to my next argument, that human rights law was also violated by Rondas Nacionales on the present case. It is on the grounds, Your Excellencies, that it is mentioned in Article 12.4 of the ICCPR that every person has the right to enter to its own country. on the present case, of course, Your Excellency. I'm sorry, Your Excellency, your microphone is on.
Sorry. Yeah, but allow me to tell you the following. If what you say is true, what is then the level of discretion that is given to a state for adopting measures in response to a risk ascertained on the basis of the best scientific evidence? Do you consider that there is or not a room of discretion for the state to react to the events that are contained in the statement of facts?
Yes, Your Excellency, states do have a certain level of discretion. Nonetheless, it is bounded upon the recommendations and the fulfillment of the dispositions contained on Article 43.2 of the IHR, which this agency has already relied that were not complied by Rondas Nacionales in the present case. Your Excellency, we contend that human rights law was violated as well, and therefore making illegal the entry regulation by Rondas Nacionales. On the grounds, Your Excellencies, that the right to enter to its own country was violated by Rondas Nacionales on the present case, since according to the General Comment 27 made by the HRC, its own country does not only mean the country of nationality, but rather that it can be applied to permanent residents that reside in the territory. And therefore, Your
Agent, when you are continuing making the argument in favor of a right of a return to one's country nationality, which is true, it's a well-established norm of human rights law. However, I come back to my early question. What is the responsibility of Rondas Nacionales to protect and guarantee the rights of life and health of its population? And by doing so, the level of protection that Rondas Nacionales grants to its population, it also benefits its neighbors, including a prepluyan. So I want you to place the hierarchy of a human rights law at play at this moment. Return to the country, health, life, personal integrity.
Of course, Your Excellency, we contend that even if Rondas Nacionales conducted a proportionality test in order to determine which rights are going to be determined, according to the General Comment 27, in order to limit the human right of freedom of movement, there may not be involved any type of discrimination regarding the application of this measure. And therefore, Your Excellencies, since there is a clear discrimination in the Section 1 and Section 2 of the entry regulation mentioned in the Statement of Agreed Facts in its paragraph 10, we contend that there is discrimination and therefore that the limitation of the freedom of movement right was illegal under international law. For the aforementioned reasons, Your Excellency.
What is the test of proportionality that you are using, and what is its legal source?
Your Excellency, we can rely, for example, that it is mentioned in the same, in the comment 14, General Comment 14 of the CESER, that mentions that whenever there's a protection of health, there is going to be the need to make a proportionality test regarding the rest of the human rights that are being affected. Therefore, Your Excellencies, since there is discrimination, we respectfully request this court to declare that human rights law was violated as well. For the aforementioned reasons, Your Excellencies, we respectfully request this court to declare that compensation must be owed to a prepluyan on the present case, since there was a clear violation of an international law, and this is directly connected to the economic detriment that happened in a prepluyan. Taking into consideration the report made by the Ministry of Tourism in paragraph 46 of the Statement of Agreed Facts, that the economic detriment was directly connected to the entry regulation. And furthermore, it is also mentioned in the Statement of Agreed Facts that whenever tourists left the territory of Segura province, they did so because Rondas Nacionales applied its entry regulation to a prepluyan by considering a high-risk country. Your Excellencies, if I may, I will now move on to pleading B, and I will address this issue into two main arguments. First, that Rondas Nacionales violated the dispositions contained on the Vienna Convention on Consular Relations and the principle of non-intervention. And third, that humanitarian diplomatic asylum may not be applicable on the present case. Your Excellencies, regarding our first argument, we contend that Article 55 of the VCCR establishes that the consular staff must at all times respect the laws of the receiving state. And furthermore, it is also mentioned that the consular premises may not be used in a way not in accordance with the consular functions. Your Excellencies, even though Article 5 of the VCCR, which establishes the consular functions, do not clearly prohibits the granting of asylum, it was mentioned in comment made by the International Law Commission of Article 55 that asylum it may not be considered as a consular function since it goes against the operation of justice of a country. Furthermore, Your Excellencies, and regarding the principle of non-intervention, we contend that it is mentioned in Article 1.2 of the UN Charter that there may not be any type of intervention regarding the internal affairs of a state. Your Excellencies, it is also mentioned in the Nicaragua case that there must be an element of coercion in order to determine there is intervention on another state. Therefore, Your Excellencies, we contend that on the present case, by using the inviolability and the immunities that the consular premises have, by granting refuge to a person that was being prosecuted by a patrulla, this was a clear element of coercion and a bad exercise of the consular functions, violating the principle of intervention and the VCCR. Furthermore, Your Excellencies, and regarding your second argument, we contend that nor humanitarian diplomatic asylum, nor the 1951 Convention relating to the status of refugees may be applicable on the present case. This on the grounds, Your Excellencies, that it is determined by this court in the asylum case that the only way that asylum could oppose the operation of justice is whenever it is made under humanitarian reasons. Nonetheless, humanitarian reasons may only be found whenever there is a fear that there may be an action of arbitrariness taken against the person. And therefore, Your Excellencies, on the present case, we contend that there is no arbitrariness, nor that the elements of diplomatic asylum or for a refugee to be present in the scheme platform was fulfilled on the present case. On the grounds, Your Excellencies, as well, that in order to be considered as a humanitarian diplomatic asylee or a refugee, the person must be a political offender and they must be persecuted. On the present case, Your Excellencies, regarding the political offense, we contend that Ms. Kimberly Foreman was not being prosecuted for a political offense. Your Excellencies, even though the respondent may rely that there are cases in the present pandemic of COVID-19 where whistleblowers have been considered as political offenders, and therefore that arbitrary actions have been taken against them, we contend that this is not the case in this present situation, on the grounds that Ms. Kimberly Foreman agreed to sign the non-disclosure agreement whenever she entered into to work at the NBL laboratory. Nonetheless, it is also mentioned in the non-disclosure agreement stated in paragraph 6 of the Statement of Agreed Facts that the breaching of this non-disclosure agreement could entail prosecution. Furthermore, whenever charges were applied towards Ms. Kimberly Foreman, it was clear that under the National Penal Code of Apertura, the breaching of a non-disclosure agreement may be considered as a common crime. Therefore, Your Excellencies, we contend that on the present case, this is not a case of whistleblowing, but rather an action that was taken in accordance with the national laws of Apertura, making Ms. Kimberly Foreman not a political offender. Your Excellencies, regarding the second element of persecution, it is mentioned in the preparatory works of the 1951 Convention relating to the status of refugees, and also in the advisory opinion given by the Inter-American Court of Human Rights, that persecution is met whenever there is a fear that a person may suffer in their life or integrity, or also that there may be taken actions of an arbitrary way. Your Excellencies, we contend that on the present case, there was no persecution towards Ms. Kimberly Foreman, since the objective elements in order to constitute persecution were not met on the present case.
If I may, because you are assuming in your argument that it's very clear that the respondent granted Ms. Beaumont asylum. But from reading the documents, I don't see that in a very clear form, because what it has been said that the state never effectively granted any kind of asylum. Can you elaborate more on why do you believe that asylum was granted? And also, since the international instrument regarding the granting of asylum were adopted many decades ago. I think there has been an evolution on the interpretation of asylum. So I just would like you to elaborate a little bit more on why you believe that asylum was granted, because I don't see that being done formally, and of course on the evolution of the concept of asylum in international law.
Of course, Your Excellencies. I'm afraid my time is over. May I briefly answer both of your questions?
Yes, you can answer. We'll take some time from your colleagues' time.
Of course, Your Excellency.
Please answer very, very briefly.
Of course, thank you, Your Excellencies. According to the Viennother's case, whenever authority is exercised towards a person, asylum is constituted, making the declaration of the state that asylum is granted only declarative and not constitutive. And Your Excellencies, regarding your second question, we contend that practice has not changed since according to the Julian Assange case, asylum has been deemed at all times as illegal under international law. Therefore, we contend that on the present case, Rondas Nacionales violated international law by granting refuge to Ms. Kim Borman. Your Excellencies, if there are no further questions, may you please accord.
Thank you. Please, the next speaker.
Mr. President, Your Excellencies, may you please record. Good morning, Your Excellencies. My name is Ileana Ochoa, and it's an honor to appear before the International Court of Justice in representation of the United Republic of Argentina, the applicant in the present case. I will speak now for 21 minutes, and I will cover issues C and D, regarding first, whether this court has jurisdiction to entertain the counterclaim presented by Rondas Nacionales, and second, whether Argentina violated international law by shooting down the mentioned aircraft. Your Excellencies, if I may, I will begin with pleading C, and I will divide this issue into main arguments. Regarding first, that the content of the reservation made by Argentina has a direct connection with the dispute presented by Rondas Nacionales, and second, that the reservation made by Argentina must be determined as valid under international law. Your Excellencies, regarding to the content of the reservation, both states, Argentina and Rondas Nacionales, had previously accepted the compulsory jurisdiction of the court. However, Argentina made a reservation limiting this jurisdiction whenever the dispute concerns military activities or whenever the dispute falls under the matters of domestic jurisdiction of the state as determined by itself. Your Excellencies, regarding to the content, specifically the military activities part of the reservation, even if there is not a definition of military activities established under international law, we contend that as determined by the South China Sea arbitration case, there are certain elements in order to be fulfilled whenever to the dispute to concern military activities. Your Excellencies, these elements can be the intervention of a military organ and also the use of a military object. In the present case, Your Excellencies, since in order to shoot down the mentioned aircraft, it was used a fighter jet, and it was piloted by Lieutenant Defensa, a military organ specifically of the Air Force of Argentina, as determined by the statement of agreed facts in paragraph 42. Therefore, Your Excellencies, we request this court to determine that the dispute concerns military activities. Furthermore, even if this court is not satisfied with this argument, and it determines that the dispute can concern also law enforcement activities, we contend that in the interpretation of the reservation, by its ordinary means, it establishes that the dispute must concern military activities. So it is sufficient whenever there are certain elements of military activities complied, such as in the present case, being the intervention of military organs and also the use of a military object. Then, Your Excellencies, we contend that the dispute concerns military activities. Your Excellencies, therefore, we request this court to... Yes, Your Excellency.
Yes, thank you very much, because you are indicating that only because there was a military activity involved, that is enough to justify the lack of jurisdiction. But I want you to elaborate a little bit more, because there have been other decisions taken by international tribunals which say that it's not only the fact of a military airplane involved what makes military an activity, and quite the contrary. There is a case that is in the Ukraine versus the Russian Federation that has been recently decided by the Tribunal of the Law of the Sea, And I would like you to elaborate a little bit more on your argument. Why do you think that the participation of a military aircraft is enough to make an activity military? Particularly because here we are also talking about civilian aviation. So.
Of course, Your Excellencies. Regarding to the case that you are referring, being the Ukrainian vessels case taken by the PCA, it establishes that there is a difference between law enforcement activities and military activities. And this difference depends also in the objective of the actions. The military activities, its objective is to protect the national security of the state, and to the law enforcement activities are those made in order to exercise power of detention and arrest. Since in the present case, Apapluya was facing a possible terrorist attack, it acted in protection of its national security. Therefore, Your Excellencies, we request this court to determine that the dispute concerns military activities, and consequently, this court would lack jurisdiction to entertain the counterclaim presented by Rondas Nacionales. Your Excellencies.
Yes, thank you, Mr. President. I'd like to ask you whether you consider that military activity and law enforcement activities are mutually are to be excluded one with respect to the other, because we can see in many places, particularly when faced with terrorist activities, where states, democratic states, call upon their military to undertake actions that may very well fall under military activity and law enforcement activities. I don't think that we can make a very clear distinction between the two of them. So I would like you to elaborate whether you don't think there are sufficient grounds based on the agreed statement of facts aiming at considering the shooting of the airplane as mainly a military activity, which would then fall under the reservation by the applicant.
Well, Your Excellency, we contend that the law enforcement activities and the military activities are not mutually exclusive. This, according to the Kirk Street case, taken also by the PCA, it determines that these are not mutually exclusive, and consequently, there can be an intervention of military organs on law enforcement activities, Your Excellencies. In the present case, since this was a military activity because of the intervention of the organs and the object, and also to the objective of the activity, we contend that it is purely a military activity. However, Your Excellency, if this court determines that it is a mix of law enforcement activities and also military activities, the reservation, because of its interpretation, it refers to the concerning of military activities. So these elements would be sufficient in order to this court to determine that the matters concern military activities. Your Excellencies, if I may, I will move on to my next submission, being the validity of the reservation made by Apapluya. Your Excellencies, we contend that the self-judging character of the reservation made by Apapluya is sufficient to restrict the jurisdiction of the court. This reservation was made in compliance with international law, since this reservation was made against the compulsory jurisdiction of the court. Therefore, since by making this reservation, there is still emanating obligations of the states in order to appear before the court and ask for it to determine if it can have jurisdiction, even if the reservation has a self-judging character. There is not a violation, neither an affectance to the compulsory function of the court. Therefore, Your Excellencies, this court must be determined as valid. Your Excellencies, with these fourth reasons, we request this court to determine that this court will lack jurisdiction to entertain a counterclaim presented by Rondas Nacionales. Furthermore, even if this court will determine that the self-judging character reservation is not valid, the matters of the dispute still falls under the domestic jurisdiction of Apapluya. This, Your Excellencies, because it happened, the matters happen inside of the territory of Apapluya, with nationals of Apapluya, and also with an aircraft that belonged to an Apapluyan airline. And furthermore, since the protection of the national security is always a matter of domestic jurisdiction, therefore, the dispute must determine domestic matters and not international matters. and then this court would lack jurisdiction to entertain the counterclaim presented by Rondas Nacionales. Your Excellency.
If you are indicating that an internal and national issue, but what can you tell us about the nature of the flight? That was an international flight. This was not an internal flight. It was a civil aviation. And also, I would like you to remind us a little bit more about jurisprudence existing regarding the reservations of the Connolly reservation. That is the one that you are relying on. Can you please let us know that?
Of course, Your Excellency. Regarding to the international flight, we contend that even if this aircraft was directed to another state, in this case, Rondas Nacionales, we contend that it must not be determined as international matter since the incident happened inside of the territory of Apapuya, and the aircraft never arrived to Rondas Nacionales, Your Excellencies. Therefore, it must be determined as a matter to be resolved by Apapuya, Your Excellencies. And regarding to the jurisprudence that Your Excellency is asking, we contend that this court has previously accepted the self-judging character under certain Norwegian loans case, whenever Norway applied it under the principle of reciprocity, regarding to the reservation made by us. And then in that case, Your Excellencies, the court determined that it lacked jurisdiction over the disputes presented by France, Your Excellencies. Therefore, we request this court to determine that the court lacks jurisdiction to entertain the counterclaim presented by Rondas Nacionales. Your Excellencies, if I may, I will now move to pleading D. And I will divide this issue into two main arguments. Regarding first, that the counterclaim presented by Rondas Nacionales must not be determined as admissible. And second, that Apapuya, even if this court determined that it is admissible, did not violate international law by shooting down the mentioned aircraft. Your Excellencies, in the alternative, that this court determines that it has jurisdiction to entertain the counterclaim presented by Rondas Nacionales, the respondent cannot claim to have standing in the present case in order to claim Apapuya for the violation of international law. This, Your Excellencies, since the claiming of international human rights can be made only by the diplomatic protection. In the present case, Your Excellencies, Rondas Nacionales cannot claim the diplomatic protection over Ms. Borman, neither Ms. Hai, since they were both nationals of Apapuya. And even if Ms. Borman was a refugee of Rondas Nacionales, it could still not exercise diplomatic protection, since according to the draft articles in Article 8 of the diplomatic protection, it is determined that states can exercise diplomatic protection over refugees that have an habitual and unlawful residence on the territory. And furthermore, states cannot exercise diplomatic protection against the state of nationality of the refugee. In the present case, since Ms. Borman never left the territory of Apapuya, and she never had an habitual nor lawful residence on Rondas Nacionales, and since it is claiming to have, it is claiming the violations of international law to the state that is of the nationality of Ms. Borman, then, Your Excellencies, Rondas Nacionales cannot have standing in the present case in order to claim the violations of international law. And regarding to the Article 3 bis of the Chicago Convention, Rondas Nacionales cannot have standing neither since this obligation cannot be considered as an erga omnes obligation. Consequently, Your Excellencies, Rondas Nacionales cannot claim any interest regarding to the dispute presented by it, and this court must determine that the counterclaim is not admissible. Your Excellencies, in the alternative,
Yes. Well, shooting an airplane, it's a very serious act, particularly when we are talking about civilians involved. And can please elaborate more? Why do you think there is the states have the right to shoot down civilian aircraft? And what is the basis of that? Because even the convention is very clear. Is very clearly stating that the use of force against a civil aircraft is not allowed. So please tell us a bit more about it.
of course, Your Excellencies, in the Article 3 bis, it is established this provision that Your Excellency is referring. However, there is an exception to these, Your Excellencies, and it's also established in the Article 3 bis that states can exercise the right to self-defense according to the United Nations Charter.
Self-defense. Why self-defense? Could you please give me some elements to justify the right of self-defense in this situation?
Of course, Your Excellencies, the Article 3 bis mentions that the dispositions established in that article does not preclude the rights of states regarding to the UN Charter. Specifically, Your Excellencies, referring to the Article 51 of the United Nations Charter, where states are allowed to exercise self-defense whenever certain elements are fulfilled. In the present case, Your Excellencies, Apapuya fulfilled with these elements, since the elements are the armed attack, the necessity, and the proportionality. In the present case, Your Excellencies, according to international law, the self-defense can be exercised against a threat of force, Your Excellencies. This according to the previous Security Council resolutions that establishes that states can exercise self-defense against active terrorism, and it does not specify regarding to the armed attack of terrorism. In the present case, since there was a possible.
Ambassador Gómez Robledo.
Sorry to interrupt you, but I'd like you to elaborate a little bit more on the right to self-defense. First of all, you've claimed in your argument that the aircraft, the pilot, the passenger, the territory, everything was appropriate. Then where do you import the foreign element? Are you pretending that Appropriate was reacting to an armed attack from Rabostayan? Of course, I heard that you started elaborating on the criteria of proportionality and necessity, but still, you are lacking the very basis of the element to claim the right of self-defense, as enshrined in Article 51 of the UN Charter.
Well, Your Excellencies, according to the UN Charter, it indeed establishes that there needs to be an armed attack. However, states are also allowed to use self-defense against a threat of force. These, according also to recent state practice from the last century, that states have used force against a threat of force, had used self-defense against a threat of force, Your Excellencies. These, for example, in the cases of Israel using as a self-defense whenever there was a threat of force in the Suez crisis, in the Lebanon crisis, and also in the operation of Entebbe. Also, Your Excellencies, United States, the Iraq has been contended the use of self-defense.
I'm sorry to interrupt you again, but then you are pretending that under international law, a preemptive strike is allowed. Are you trying to persuade this court that self-defense can be carried out as a preventive action before the armed attack actually happened?
Well, Your Excellencies, if this court is not satisfied with the argument of self-defense, we do contend that the preemptive self-defense can be applicable in the present case and that it constitutes customary international law. Your Excellencies,
Preemptive self-defense, if I may ask, what are the elements in this case for preemptive self-defense if you have not been able to establish that a right of self-defense?
well, Your Excellencies, the elements of self-defense is principled the imminence of a possible armed attack, Your Excellencies. Furthermore, there is also need to be used the necessity and the proportionality elements. In this case, Your Excellencies, Appropriate exercises self-defense, the preemptive self-defense regarding a possible threat, regarding a threat of a possible terrorist attack in its territory. Therefore, since the preemptive self-defense constitutes a customary international law because of the state practice that we just before contended, and also since the states are feeling obligated to use force and preemptive self-defense against possible attacks that could happen in their territory, we contend that this is a figure of customary international law, and the Appropriate lawfully exercised it, since it was the compliance with the principal element that was the imminence. In the present case, Your Excellencies, since there was a terrorist threat given on account of the Interpol report, and also that there was an unauthorized aircraft flying over the airspace of Appropriate that did not, that Appropriate tried to communicate with it, and it lacked this possibility because it failed to respond it, and it also failed to respond to the.
Yes. And very quickly, because I'm very intrigued on your arguments, because it is quite a contradiction, in my opinion, when you are talking about an issue just within the internal jurisdiction of a state, invoking Article 55, because Article 55 is linked to external armed attacks. So I'm not very sure. I think you are going into a difficult road if you talk about Article 51 of the UN Charter and about the preemptive attack. So please tell us clearly why do you think Article 51 is applicable, and whether this is not contradictory to the previous arguments about the national clause and non-interference.
Well, Your Excellency,
Please conclude your remarks in 2 minutes. We will not have extra time.
of course, Your Excellency, no problem. Regarding to the this question of Your Excellency, there is an allowance to use self-defense also against non-state actors, Your Excellencies. This according to the Security Council's Resolution 1368 and 1377 that allows states to use force against acts of terrorism. Therefore, Your Excellencies, it is not necessarily the external armed attack, since the self-defense can now be used against non-state actors. For instance, Your Excellency, yesterday there was an incident that United States, by the instructions of Joe Biden, sent an armed attack against the insurgent group in Syria, Your Excellencies. This is a proof that there is an off-state practice of self-defense against non-state actors, and also as a preemptive self-defense, Your Excellencies. Therefore, since Apropluya complied with the elements of the imminence because of the possible terrorist attack, and the failing to communicate with the aircraft flying over the airspace, and that did not obey to the instructions given by Apropluya, therefore it complied with the imminence element. Furthermore, Your Excellencies, it also complied with the proportionality element, since it shoots to the wing, and it always prevailed the protection of and the safeguard of the civilians that could be on board, Your Excellencies. So whenever a person shoots a wing of the aircraft, the aircraft could still be flying for a long time in order to force its landing. In the contrary, if we would shot it to the fuselage, then it would affect the life of the passengers. Therefore, Your Excellencies, Apropluya complied with the proportionality element. Furthermore, regarding to the necessity, Apropluya exhausted all the necessary elements before using force against the mentioned aircraft. This, since it intended to use visual signals and also intended to communicate via radio and shoot tracers against the mentioned aircraft in order to intercept it and force its landing. Therefore, Your Excellencies, since Apropluya lawfully exercised the preemptive self-defense that is a customary international law, we request this court to determine that Apropluya did not violate international law.
Thank you very much. Time's up.
May you please the court.
The microphone over to the bailiff.
Mr. President, Your Excellencies, may it please the court. My name is Maria Fernanda Salgado, and I am very honored to be in front of the International Court of Justice on behalf of the respondent. For the following 21 minutes, I will be addressing the first two issues of the present dispute. First, Rondas did not violate international law by applying its entry regulations to Apropluya and must not be required to compensate for its economic losses. And the second, Rondas did not violate international law by not handing over Ms. Kaimblad Vermund. Afterwards, I will yield the floor to my co-agent, Ms. Sara Contreras, who will address the last submissions. The third, this court has jurisdiction to adjudicate over Rondas counterclaim regarding the Mansion Airways aircraft incident. And the fourth, Apropluya violated international law by shooting down said aircraft. Finally, we will be leaving 2 minutes for sub-rebuttal. May it please the court. Your Excellencies, Rondas challenges all of Apropluya's submissions regarding the first claim. Your Excellencies, because we complied with the international health regulations. Firstly, we contend that we have the right to establish these additional health measures, because in accordance with Article 43(1)(a) of the International Health Regulations, states can implement additional health measures when they aim to achieve the same or a higher level of protection than the one granted by the WHO recommendations. And furthermore, Your Excellencies, in the same line of argument, Rondas measures aim to achieve this higher level of protection, since it has been recognized by the World Health Organization that entry regulations aid in delaying the entry of the virus to a state, which allows it to better prepare their healthcare system to tackle this public health emergency in the most suitable way, Your Excellencies. And furthermore, this has been reinforced by both the World Trade Organization and the International Civil Aviation Organization, the maximum authorities of the respective areas. Your Excellencies, secondly, we do contend that we complied with the procedural requirements called upon by our counterparts. Your Excellencies, firstly, they mentioned that we did not comply by following scientific principles. Your Excellencies, under Article 1 of the IHR, Scientific principles involve laws of nature that are known by everyone and through science. Your Excellencies, we follow the scientific principles because we were in the midst of a new strain of virus, of COVID-18, Your Excellencies, and we used the information available in order to establish our additional measures. The second requirement invoked by a friends in argument, Your Excellencies, would be the usage of scientific evidence.
Yes, I thank you for that. Precisely, I want to ask you about the scientific evidence and the evaluation that you did, because it's very clear that the international health regulations clearly do not recommend the application of restrictive measures regarding international transportation and entry into the different countries. And in the case, there was also a very clear recommendation by the WHO not to apply those kind of measures. And of course, they are the international authority on health issues. So I want you to elaborate why, even if you have a recommendation not to apply those kind of measures, you decided to do that, and what kind of scientific principles and scientific evaluations you did to decide otherwise.
Your Excellency, regarding the last part of your question, we carried out a careful risk assessment throughout 7 days in order to implement these additional health measures. And we also communicated the scientific rationale that we would based on this risk assessment to the WHO and the international community as required by the international health regulations. Also, regarding scientific evidence, Your Excellencies, precisely our counterparties mentioned that in paragraph 7 of the Statement of Agreed Facts, there is the establishment that COVID-18 is capable of human-to-human transmission. It has a basic reproduction rate of 1.4 to 1.6 and many other scientific evidence regarding this disease. And pertaining the first part of your question, Your Excellencies, indeed, there was a WHO recommendation to not implement these travel restrictions. Nonetheless, we did take into account this WHO guidance, and this was based on previous experiences, Your Excellencies, for example, influenza and even the situation of COVID-19. In a report situation on COVID-19 virus, Your Excellencies, on February 2020, these three organizations that I mentioned, the World Health Organization, the ICAO, and the World Trade Organization, all recognized that in the early stages of an outbreak, it is adequate to implement these travel restrictions to better manage these pandemics, Your Excellencies. Therefore, we can see that we have taken into account WHO guidance. And furthermore, we contend that the additional measures that a state can take are not limited to what the WHO has recommended.
Thank you very much. But I clearly see that you are concentrating your argument on the scientific basis for making your decisions, and you pretend to have complied with the standards of the international health regulations. However, in your risk assessment, did you include or incorporate in any way the economic and social impact that your measures would cause on Aprepluia, because you have agreed that in the facts that most of the tourism present in those days in Aprepluia fled as a result of the decision by your government to put Aprepluia under the category of high-risk country. What is your assessment about the impact, and what is your position regarding the claim by Aprepluia to be compensated for the economic and loss that it suffered? Thank you.
Your Excellency, to answer your question, I believe that there is a very important point to stress here, and that is that our counterparties failed to mention that Aprepluia imposed entry regulations also, and they even did so prior to Rondas Nacionales adding it to its list of high-risk countries. And this can be found in paragraph 27 of the Statement of Agreed Facts. Therefore, Your Excellencies, the tourists that left this link cannot be directly established or only attributed to Rondas Nacionales, because Aprepluia also had this additional entry regulations, Your Excellencies. And furthermore, in any event, Your Excellencies, precisely regarding your question of compensation, this court has established that in order for a state to attribute economic losses to another state, there must be a certain and direct connection between the actions of the injured state and of the allegedly responsible state. But Your Excellencies, the World Bank has made numerous reports regarding the COVID-19 situation, where it mentions that in the midst of a public health emergency of international concern and of this level, Your Excellencies, both the diminition of tourism and economic losses are expected. Therefore, Your Excellencies, we contend that it is not feasible for Apepluya to attribute its economic losses to Rondas Nacionales. And furthermore, and alternatively, we contend that Apepluya contributed to their own loss of profit, Your Excellencies. And in this sense, Rondas Nacionales must not be required to compensate for Apepluya's economic losses that it itself provoked. And Your Excellencies, I would also like us to keep in mind that here we are dealing with.
Yes, please elaborate on that argument that you just mentioned, that the applicant was caused their own damage, please.
Your Excellency, we contend that the applicant state contributed to its own loss of profit because they were the first ones precisely to establish this additional health regulations. They completely closed their borders of Segura province, Your Excellencies. They forbade the entry and the departure of that province, which also caused these diminishing tourism because Segura province was the one that brought in the most income from tourism sector. And in this sense, Your Excellencies, because they contributed to their own loss of profit and because there was no violation of Rondas Nacionales of international law, it must not be required to compensate. But in any event, if this court finds to the contrary, we would argue that there must be a necessary diminish in the economic compensation that Rondas Nacionales must grant to Apepluya, as was done in the MDT versus Chile case, Your Excellencies.
Let me go back to the restrictive measures. Please elaborate on the standards of temporary necessity, legality, and proportionality of the restrictive measures that you apply in order to determine whether they are valid in international law.
Your Excellency, precisely as mentioned by our counterpart, they intend to indicate that the necessity and proportionality criterion are met because, or are not met because they were not the less restrictive measures available. But Your Excellencies, we would like to challenge this argument. Firstly, because Rondas Nacionales only partially closed their borders, not completely. And to this, I would like to draw the court's attention to the COVID-19 situation, to countries such as Mongolia, New Zealand, Your Excellencies, and many others that completely closed down their borders. Furthermore, they contend that, or let me bring another example of Brazil, Your Excellencies. They previously had entry regulations and they took them down. And in the next month of them taking down these restrictions, they saw a 3.4% increase in daily COVID-19 cases. Your Excellencies, we contend that these were the less restrictive measures available in order to achieve the same level of protection. Because without restricting the movement, Your Excellencies, we would have a collapse of our healthcare system and we could not be able to provide the right of health to people, not only of Rondas Nacionales, but to all the region, Your Excellencies. And because we took the less restrictive measures available, we contend that our measures were necessary to protect the health of people. Because we were dealing with a new strain of virus, Your Excellencies, COVID-18, that causes uncontrollable coughing, difficulty in breathing, high fevers, chills, listlessness, and even death, Your Excellencies. We were dealing with lives of people, and we could not take any chances. But Your Excellencies, proceeding to Apepluya's second submission, we contend that we did not violate international law by not handing over Ms. Campbell Vermund. In this particular case, we have to take into account that there are rights and obligations, and these are interconnected, Your Excellencies, not just in a bilateral relationship between the sending and the receiving state, but also vis-a-vis the asylum seeker. Therefore, Your Excellencies, we contend that we did not violate international law. Firstly, because just as was Your Excellency's Flores concern, we did not grant diplomatic asylum. But even if we did, we contend that we had a right to grant diplomatic asylum. And furthermore, we had the obligation.
agent, do you have a right to grant asylum in consular premises? What is the state of international law with regard to consular premises and asylum?
Precisely, Your Excellencies, we affirm that we do have a right to grant diplomatic asylum on consular premises because we contend that it is a consular function. This would be under Article 5 of the Vienna Convention on Consular Relations, Your Excellencies, which established that a consular post can exercise the functions that are expressly listed, consented by both of the parties, whether it be tacitly or manifestly, or established in other rules of international law. And Your Excellencies, in this particular case, we are aware that it is not listed under the VCCR and it is not consented by both of the parties, but it is a rule established under general international law. Your Excellencies, there have been numerous...
However, agent state practice recognizes the diplomatic premises, both the chancellery and the residence of the ambassador, but not the consular premises. Will you please give us more elements on that?
Your Excellency, some cases of state practice would be Tony Chung, Your Excellencies, the Durban Six, and many other cases. And regarding opinio juris and also state practice, there have been numerous diplomatic correspondence between states such as the United States, United Kingdom, Mexico, Ecuador, and Belgium that prove that this is a consular function under customary international law, Your Excellencies. And furthermore, as...
Yes. Well, I am not convinced of that argument. I think it's clear that the VCCR does not contain any specific provision on giving asylum to foreign nationals in consular premises. I think, and how do you combine that argument that you are making with the duty of all of consular officers to respect the laws and regulations of the receiving state? And also tell us more about the legal practice, because I think there is a division at the international level regarding the right to asylum, and I think there is a very particular practice in Latin America particularly, but it's not shared by other legal scholars. So please tell us more about these three issues.
Your Excellency, and well, comprising all of the three issues and making an emphasis on the compliance with the law of the receiving state, Your Excellencies, we also contend that there is another ground to grant Ms. Borman with diplomatic asylum, and this is the one precisely mentioned by our counterpart, arbitrariness. It was recognized by the International Court of Justice that a state can grant diplomatic asylum under exceptional circumstances, such as when there is an imminent threat that the asylum seeker might be facing arbitrary action exercised by the receiving state. In Your Excellencies, in international law, arbitrariness cannot be equated to domestic unlawfulness. And this was even recognized by the International Court of Justice in the Electronica Asícula case and in the asylum case. Your Excellencies, precisely, we contend that we do have the obligation to comply with the laws of the receiving state. Nonetheless, we also had the obligation to protect Ms. Borman of the arbitrary action that was going to be exercised against her. The evidence of this arbitrariness.
Judge Gómez Robledo?
Yes, assuming that Ms. Borman was never granted diplomatic asylum, as you pretend, since the relevant authorities allege that they were just assessing her request, did Rondas Nacionales have a right to qualify unilaterally, as you are right now saying, the offenses that were charged against her by the Apretruya's system of justice? Did you have a right to unilaterally qualify those offenses? And I'd like also you to elaborate more on the distinction between diplomatic and consular missions under international law. do you think that diplomatic or consular missions enjoy extraterritoriality? And what is the distinction between the enjoyment of privileges and immunities under international law, under both the VCDR and the VCCR, and a status of extraterritoriality? Thank you.
Your Excellency, regarding your last question, the main difference I would point out between diplomatic missions and consular posts would be precisely regarding the inviolability of their premises. Embassies enjoy full inviolability of their premises, while consular posts only enjoy functional inviolability, which means that the premises are inviolable that are used exclusively for the work of the consular post. And Your Excellency, regarding your first question, I believe that it is very important to make a clear distinction, Your Excellencies, between our standard and the standard employed by our defense argument. Because in the standard of arbitrariness, Your Excellencies, that would allow a state to grant diplomatic asylum to an asylum seeker regards only arbitrariness, but not so much as the offense committed by the person, but focuses on the actions of the authorities. And in this sense, the arbitrariness in this particular case can be seen through numerous facts. Firstly, because as Your Excellencies might see in paragraph 32 of the Statement of Agreed Facts, Ms. Bormund was charged on exactly the same day that Rondas added Apepluya to the list of high-risk countries, which was the direct consequence of Ms. Bormund's disclosure on the JV-18 situation regarding Apepluya. Your Excellencies, the second evidence of this arbitrariness can be seen through the fact that she was being charged for public disorder. And to this, I would like to bring the court's attention to the situation of whistleblowers, people who face a hostile environment during public health emergencies of international concern. There have been cases such as Sang Sang, Your Excellencies, a Chinese national that disclosed the COVID-19 situation. She was charged and she was detained, and the United Nations High Commissioner for Human Rights recognized this to be an excessive clampdown of her freedom of expression. Another case would be of Dr. Li Wenliang, the first person to disclose the COVID-19 situation to the world. Your Excellencies, he was constantly being accused of making false comments against the government. He was facing retaliation by the government, and this was recognized as an attempt to silence him. Your Excellencies, Ms. Bormund was precisely in this situation. Yes, she was being charged, but arbitrariness does not exclude this, or the lawfulness of the charge does not exclude from the fact that a state can exercise arbitrary action against a person. Ms. Bormund disclosed information that Apepluya did not want the international community to know, even though they knew and they were aware that this could cause catastrophic consequences to the international community regarding JV-18 and the spread, Your Excellencies. Therefore, because there was this exceptional circumstance, we contend that we did not only have the right, but the obligation, Your Excellencies, to protect Ms. Bormund. Just as in the COVID-19 situation with Ms. Bormund, we could not take any chances. If there are no further questions, thank you.
Thank you very much. Thank you very much, Ms. Salgado. Now we turn over to your co-agent. You have the floor, agent.
Mr. President, Your Excellencies, and may it please the court. My name is Sara Contreras, and today I'm very honored to be standing in front of the International Court of Justice on behalf of the respondent. For the next 22 minutes, I'll be addressing the last two submissions of the present dispute. The third, that this court has jurisdiction over Rostallo's counterclaim concerning the maintenance civil aircraft. And the fourth, Apepluya violated international law by shooting down at the maintenance civil aircraft on June the 26th. Finally, we will be leaving 2 minutes for sub-rebuttal. May it please the court. Your Excellencies, we challenge that Rostallo's counterclaim concerns military activities. Your Excellencies, it is true the concern that Judge Flores pointed out to our to the second agent for the applicant. And this because in accordance with the case concerning the detention of 3 Ukrainian naval vessels, the International Tribunal on the Law of the Seas, in paragraph 64 to 66, that the very just nature of a vessel cannot determine whether if this concerns a military activity or not. In this sense, Your Excellencies, in that case, it was determined that in order to know if a military reservation is applicable, yes, we have to look at the nature of the activities, but also, Your Excellencies, we have to take into account the core of the dispute. Now, allow me to draw, Your Excellencies, a parallel between that case and the case at hand. Your Excellencies, in that case, Russia had a military reservation, just as the one that Apropluia filed in 2002. Now, in that same case, Your Excellencies, the vessel was prevented from continuing its navigation by a military vessel of Russia. But still, Your Excellencies, the International Tribunal on the Law of the Seas, following this reasoning, determined that because of the core of the dispute there was the prevention of navigation of a vessel, then the Russian reservation regarding military activities was not applicable. Your Excellencies, it is Rondas Nacionales' contention that the ICJ must follow and do the same, Your Excellencies, because here, the core of the dispute was an innocent civilian aircraft navigating, following and wanted to arrive to Bogpadayo, prevented by a military aircraft, Your Excellencies. Nonetheless, the core of the dispute here was also the prevention of continuing its route to Bogpadayo. With this in mind, Your Excellencies, it is Rondas Nacionales' contention that its counterclaim does not concern military activities, and thus the reservation regarding military activities is not applicable. Furthermore, Your Excellencies, we also contend that the second part of the reservation, which is that that reservation will prevent this court to adjudicate upon matters that falls within Apropluia domestic jurisdiction. These, Your Excellencies, because Rondas Nacionales' contention is that, and this was actually the concern of Judge Flores, this was an international air service. This because in accordance with paragraph 43 of the Statement of Agreed Facts, the final destination of the flight A7PBB4 was Bogpadayo Airport, Your Excellencies, not within Apropluia. With this in mind, and following what this court has solved in the Interhandle case.
Judge Gomez Robledo.
Thank you very much, Mr. President. Why do you say that the aircraft had as its destination the airport of Ranostallo? It never got a travel authorization. So no one could have known what the final destination the pilot had in mind. There was no travel plan, no authorization. So we can hardly believe that can hardly believe that the international element of that aspect of the case is met. First of all. Second, if you allow me, let me go back to the your argument regarding the Ukraine case to which you referred to. Is that case already a final one? Because to the best of my knowledge, that case has only reached the level of provisional measures. So can we take the conclusions by ITLOS as definite?
Mr. Robledo, if I may address your second question first. And Your Excellencies, it is true that the case concerning the 3 Ukrainian naval vessels is regarding provisional measures. Nonetheless, Your Excellencies, I believe that the reasoning and the interpretation of a military reservation gives guidance to this court, Your Excellencies, of how to interpret and applicate or not these types of reservations, Your Excellencies, even though it might not be a final decision, Your Excellency. Furthermore, presiding to your first concern, Your Excellency, and that is, yes, we are also agreeing that the Apropluian authorities, they could have not known, for instance, that it was a flying towards Bogpadayo, Your Excellencies. Nonetheless, we are contending that it was an international flight because Mrs. Guhai, the pilot, placed a telephone call to the Mantan Airways in Bogpadayo Airport, telling them that its final destination was Bogpadayo in order to seek asylum. But Your Excellencies, in any event, if we consider this a domestic flight, still, it will fall within the international jurisdiction. Excellencies, because in accordance with Article 3 bis D of the Chicago Convention, civil aircraft, if it's regulated in any state, for instance, in this case of Apropluia, it must follow and it must comply with minimum standards pointed out by the Chicago Convention. For instance, the
without a clear plan and just by leaving a message in a phone, do you think that they have some responsibility on the facts that follow? Because why don't you elaborate on that particular part?
Of course, Your Excellency. This will be deeply arguing claim number 4. However, answering to your question, Your Excellency, it is Rondas Nacionales' position that this was not at any moment the responsibility of or the fault of Mrs. High or Mrs. Borman. Your Excellencies, if we can look at Ilsa's report in paragraph 43 of the Statement of Agreed Facts, Mrs. High had made advanced arrangements with Segura Airport personnel, Your Excellencies. Segura Airport personnel, they knew about these, Your Excellencies. Thus, Mrs. High provided with the information of the civilian aircraft. And it's Rondas Nacionales' position. Mrs. Guhai is not responsible for this. If I may proceed, Your Excellencies, regarding the admissibility objection presented by agent of the second agent for the applicant. Your Excellencies, in accordance with Barcelona traction case solved by this court, it distinguished between the erga omnes obligations and the erga omnes partes obligations. In this regard, Your Excellencies, it is respondent contention that we have an interest within the second category. This with Article 2 of the ICCPR, states have a legal interest to make the other parties of that treaty to comply with the obligations. This, Your Excellencies, this interpretation was recognized by the Human Rights Committee of the UN. Now, Your Excellencies, this court, in the Abre case, Belgium versus Senegal in 2009, recognized that Belgium had legal standing due to erga omnes partes obligations. With this in mind, Your Excellencies, Apropluia violated specifically Article 6, Paragraph 1 of the ICCPR in the law of Mrs. Bormund and Mrs. High. And it is Rondas Nacionales' legal interest to be today in front of this honorable court because they breach to protect the right of life of these two women, Your Excellencies.
There was an intent on the side of Apropluian to take the life of the victim?
Your Excellency, it is Rondas Nacionales' contention that we cannot call it as an intentional. Nonetheless, and I will prove in claim number 4, due to the actions taken by Apropluian authorities, yes, Your Excellencies, they violated the right to protect the life of people on board of that civilian aircraft. Now, Your Excellencies, if I may proceed to claim number 4, which is Apropluia violated international law by shooting down a demanded civil aircraft. Your Excellencies, before I proceed to the argument regarding self-defense, I would like to take some steps steps back. And what happened before the shooting? This, because in accordance with Article 3 bis B of the Chicago Convention, yes, it is recognized that states can conduct an interception to an aircraft that, for instance, is flying without authorization. Your Excellencies, but for this, the intercept, oh, I see that.
We will have the time. I have a problem with the other two judges. Wait just 1 second.
Is Judge Flores Liera back?
No, we will wait just 1 second. I think she's just entering the room. Yes.
Thank you. Excuse us, Ms. Contreras. This happens in virtual life.
No problem, Your Excellency. If I proceed with the argument, Your Excellencies, and I want to take this honorable court some state back before the shooting, Your Excellencies, and this is the interception. The interception procedure, Your Excellencies, has the sole purpose to know the identity of the civilian aircraft. Furthermore, yes, it can give any other instructions, for instance, to deviate from its apparent flight path or to land at some designated airport. With this in mind, Your Excellencies, even if we consider that Apropluia had the right to conduct an interception, it was not Apropluia's last resort. This because it is a well-recognizable principle that interception must only be taken as a last resort, since this put in danger the human life of people on board and also the safety of the aircraft. Your Excellencies, if I can draw the attention of this court to paragraph 41 and 42 of the Statement of Agreed Facts, where Prime Minister Jaraca and also the commanding officer explain that the main objective and also their concern to carry out the interception was to know the identity and the mission of this civilian aircraft. Your Excellencies, these two objectives could have been achieved by further investigation. These conclusions was explained in Tiffany versus the United States. Your Excellencies, if these were the main concerns for conducting an interception, for instance, if military Apropluian authorities would have made further investigation with Segura Airport personnel, they will have known two things, Your Excellencies. First, who was on board of that civilian aircraft, and second, where it was heading, Your Excellencies. This because in paragraph 43 of the facts, it is established that Mrs. Wu Hai made previous arrangement with airport personnel of Segura province, Your Excellencies. Thus, it is Rondas Nacionales' position that the interception was unlawful itself because it was not Apropluia's last resort. In any event,
Judge Gomez Robledo.
Thank you very much, Mr. President. Allow me to go myself also a couple of steps back. How could you explain that according to the statement of agreed facts, after the Ministry of Foreign Affairs of your country had stated on 10 June 2018 that it had no obligation whatsoever under international law to surrender Ms. Vormund, why then on June 23, the same Ministry of Foreign Affairs announced its intention to permanently close the consulate in Segura province? And I'll tell you why this is relevant. Why no indication was given as to the fate of Ms. Vormund, who remained under your protection? Moreover, why the consul and his staff left Apropluia earlier than what had been announced? what are, in your view, the consequences of such behavior? Could we conclude that at the time of the departure of the members of the consulate, your government had considered that Ms. Bormund was no longer in danger and did not need any kind of protection? Thank you very much.
Judge Robledo, it is true, Your Excellencies, that 2 days prior of this incident, we had an evacuation flight, Your Excellency, of people who was in the consulate of Segura province. But Your Excellencies, Rondas Nacionales respect the law, and we wanted to take carefully decision regarding the final decision of Mrs. Bormund, Your Excellencies, and we did not want, Your Excellencies, to take for granted also the decisions, for instance, of applicant. And this was stated, this was explained in the statement of agreed facts, that Rondas Nacionales wanted to carefully analyze the situation of Mrs. Bormund before making a final decision, Your Excellency. And we deeply regret that Mrs. Bormund was on that civilian aircraft on June the 26th, Your Excellency. We do regret that. Now, Your Excellencies, returning to the fact that in any event that a employee had the right to conduct an interception, the shooting down at the manned civil aircraft was against international law. But before I start, Your Excellencies, it is important to draw a line between the right of self-defense as recognized by this court, customary international law, and the UN Charter, and anticipatory or preventive self-defense. Your Excellencies, and this was pointed out by Judge Robledo, a sine qua non condition for states to exercise their right of self-defense, an armed attack must have occurred. With this in mind, Your Excellencies, it is impossible to believe that an innocent civilian aircraft with a technical impossibility to communicate, following its blind route to Bocpadayo, could be amount to an armed attack, Your Excellencies. And this per se will make unlawful the shooting down at the manned civil aircraft, because the first condition for exercise the right of self-defense was at any moment accomplished. In the alternative, Your Excellencies, even if we consider that the anticipatory right of self-defense exists under customary international law, there was no imminent threat from the manned civil aircraft to the appropriate national security. Your Excellencies, Rondas Nacionales understands that terrorism has become a threat to states after 9/11, for example, which was a tragedy. However, we have to remember what happened there and what happened with the conduct of the civil aircrafts there involved. For instance, in accordance with a US report of the chronological order of events, I would like to remind this court of the conduct of Flight 11, 77, and 93. For instance, Flight 11 had a rapid descent, or it was flying way too low. This raised alert in the officers of the US. Flight 77, Your Excellencies, was traveling at a high speed of rate. Finally, Flight 93 had a sharp descent and the plane rose upside down. Your Excellencies, at any moment, did the manned civil aircraft had a conduct that would make appropriate authorities think that it was about to crash into governmental buildings, Your Excellencies? It was flying at a normal rate speed. Furthermore, Your Excellencies, even if we consider this was an imminent threat, it was neither necessary nor proportional. It was not necessary, Your Excellencies, because if the only purpose of the shooting at the wheel route area was to make these civil aircraft stop, this could have been achieved by other methods. For instance,
I note that you haven't replied to my question as to why the consul in Segura province fled, leaving Ms. Bormund, who was under the protection of the consulate, with no protection. But would you agree that if it were proven that Ms. Borden was left without that protection. Your government claimed to have given her, because you claim to have given her that temporary protection. Would you still consider that Rondas Nacionales has standing to related to the shutdown of the aircraft?
Before you reply, I'll give the floor to Judge Flores Liera, and then I'll ask you to answer both questions in the remaining time. Judge Flores Liera.
Well, part of my question was already asked by Ambassador Gomez Robledo, but I want you to elaborate more, because there was a threat of terrorism act, and there was a clear attempt of establishing contact, and even to send to the plane some signals that they needed to land, and they never responded. So why are you arguing that it was an attempt that there were other measures available that could have resorted before? Tell us, because in this case, there were some attempts to establish contact, responses were never returned, and there was also a threat of terrorism.
Answering to Judge Robledo's question, Your Excellencies, as I previously stated, Your Excellency, Rondas Nacionales wanted to carefully analyze the decision of Mrs. Bormann before taking to our territory. Now, Your Excellencies, we deeply regret that Mrs. Bormann sneaked out from our consulate in Segura province, but at any moment did we know that she escaped, Your Excellencies. We really wanted to protect her, and we will still have legal standing because Apropluia violated its obligation to protect the right of life. Because by shooting that civilian aircraft, it killed her, Your Excellencies, and not just her, but also Mrs. Wu Hai, the pilot. Now, finally, Your Excellencies,
Continue, please. Finish the questions.
Thank you, Your Excellency. Regarding the Judge Flores question, Your Excellencies, yes, it is true. And even if we consider, because yes, we had a report from the Interpol of a terrorist attack. But first, Your Excellencies, that report was for the general province and not just Apropluia. But still, Your Excellencies, we understand the fear that applicant might have felt that day. But Your Excellencies, yes, there were other methods. For instance, in accordance with ICAO recommendations, in order to stop a civilian aircraft, there are two other options before firing at the wind route area. For instance, we have the reheat effect. This means, Your Excellencies, that the fighter jet, in this case, the intercepting aircraft, will go in front of the ROC civilian aircraft and flash its back engines, Your Excellencies. The other method will be to prevent the flight path of the ROC civilian aircraft like that in order to make the speed decrease, Your Excellencies. Thus, because there were other methods, Your Excellencies, even if considered as an armed attack, it was not necessary and neither proportional to kill an innocent life of people. Thank you, and may it please the court.
Thank you. Time is up. Now, let's go to the applicant's rebuttal for 2 minutes, please.
Your Excellencies, may it please the court. 2 points for our rebuttal. First, the respondent relied on the cases Dr. Lee and Shan Shan of whistleblowing to prove that Ms. Bormann was subject to arbitrary actions. Nevertheless, parallelisms may not be made regarding these cases, since the punishments applied did not have a legal basis, while Ms. Bormann was being prosecuted for crimes expressed in the National Penal Code of Apropluia, making clear that there was no arbitrariness in the present dispute. As a second point, the respondent claimed the violations of human rights by the government's practice obligation. However, it failed to prove its standing to claim the violations to Apropluia, since the only manner to claim these violations of human rights is by diplomatic protection, as this court has previously ruled in the Natsupon case. Your Excellencies, may it please the court.
Thank you. Now, the respondent for 2 minutes for the counter rebuttal.
Mr. President, Your Excellencies, Anastasia challenges both of these submissions for sub-rebuttal. Your Excellencies, as it was clearly stated by the International Court of Justice in the Electronica Sicola case, the fact that a crime is determined in the penal code or that is lawful under domestic law does not amount to a fact that the state cannot exercise arbitrary action against the person. Arbitrariness can still be exercised while complying with domestic laws. Your Excellencies, Michelle Bachelet, the United Nations High Commissioner for Human Rights, just today, just this morning, accused or put the attention of the international community on states such as China, because she indicated that they had used COVID-19 as a pretext to shut down further the freedom of expression. The United Nations Human Rights Watch indicated that around in China, 17,000 people were being persecuted for disclosing information. 41 countries have also targeted people that disclose information regarding COVID-19 situation, Your Excellencies. And furthermore, regarding their second submission, we contend that there is legal interest because in accordance with the ICCPR and with General Comment 31 of the United Nations Human Rights Committee, Your Excellencies, every state has an interest in the performance of the obligations established in the covenant by other states, Your Excellencies. There are obligations erga omnes partes. Therefore, because Apropluya violated the right to human life of Ms. Bormund and Ms. High, a right contained in the ICCPR, Anastasia does have a legal interest in bringing this contract claim to the court. Your Excellencies, Anastasia did not violate international law. While Apropluya deprived both of Ms. Bormund and Ms. High of the right to life, Your Excellencies. Thank you. May it please the court.
I thank you. I thank agents of applicant and respondent for the submissions. I now invite my fellow judges to join me at the judges' room for deliberation. This hearing is adjourned.
Teams and spectators, please remain in the room.
Muchas gracias a todos, equipos, enhorabuena de nueva cuenta por su magnífica presentación. Y pues tiene la voz el presidente del tribunal, el embajador Joel Hernández, para pues proceder un poco a que nos compartan sus impresiones sobre la final. Muchas gracias, embajador.
Bueno, muchas gracias y empezamos en nombre de este jurado agradeciendo mucho al equipo organizador de YESUP, a Liliana Olvera aquí presente y al maestro Alejandro Celol, consultor jurídico de la Cancillería, por habernos honrado en esta invitación para formar parte de este panel. Vamos a proceder de la siguiente manera. Vamos a escuchar los comentarios generales de la embajadora Socorro Flores. Inmediatamente después, los comentarios generales del embajador Gómez Robledo. Seguido, la embajadora Socorro Flores va a leer las premiaciones que se dan las distintas categorías del concurso y al finalizar, el embajador Juan Manuel Gómez Robledo leerá los resultados de las finales. Sin más, le paso entonces la palabra a la embajadora Socorro Flores.
Pues muchas gracias. Quiero empezar realmente felicitándolos a todos y a todas ustedes. Han hecho un trabajo extraordinario que demuestra no solamente el interés y el amor por el derecho internacional, el trabajo para poder preparar, para poder revisar los precedentes, para poder dominar sus temas, el manejo del idioma. Creo que podemos ver una gran preparación y un muy gran nivel en los dos equipos que estuvieron participando. Realmente quiero reconocer todo ese esfuerzo. Creo que en los dos equipos fue una deliberación difícil, la de los jueces, porque hemos visto una gran capacidad en los dos equipos. Por supuesto, siempre hay un ganador. Simplemente yo quisiera señalar que la argumentación de los dos fue buena. Si bien hubo una mayor, sería importante que cuiden la congruencia de los argumentos para asegurar que no entran en contradicciones entre argumentación para una defensa que después pueda verse afectada por comentarios al defender otro de los puntos. Creo que eso sería el aspecto que yo destacaría, la importancia de la congruencia. Creo que los dos equipos mostraron no solamente conocimiento, sino buen manejo del foro, ¿no? Para poder responder a las preguntas que se les hacían. A veces no necesariamente respondían la pregunta de manera muy específica, pero quiero realmente felicitarlos. Fue para mí no solamente un gusto el participar en esta competencia YESUP como jueza, sino también ver la gran calidad de los estudiantes mexicanos y el muy buen conocimiento que tienen del derecho internacional.
Gracias, embajadora. Embajador Gómez Robledo.
Bueno, no tengo mucho que agregar a lo que acaba de decir mi colega, la jueza y embajadora Socorro Flores. Yo también quedé verdaderamente impresionado de la extraordinaria agilidad de ambos equipos, agilidad intelectual, agilidad escénica, porque supieron, no se dejaron amedrentar por las continuas interrupciones de los miembros del tribunal, que algunas eran especialmente incisivas. A todo en general contestaron y contestaron con fundamento, con un conocimiento profundo del memorial y contramemorial presentes en este caso, y con, sobre todo, como decía, grandes dotes de argumentación en el alegato oral. Muy impresionante notar también que no tenían el apoyo de ninguna nota, de ningún apoyo visual. Todo lo que expresaban era algo que tenían perfectamente interiorizado. Me fijé mucho en el manejo corporal, en lo que se suele denominar como el body language, y es realmente impresionante. Tienen un gran control de sí mismos y nunca se dejaron, nunca sintieron o no dejaron sentir por lo menos que las preguntas los afectasen. Por tanto, para mí es muy grato constatar el camino que ha recorrido la enseñanza del derecho internacional en México. Esto es algo que no existía hace tan solo unos años y es muy impresionante ver cómo con la edad tan corta que tienen, todos podrían ser obviamente mis hijos, pero eventualmente hasta mis nietos, tienen un manejo de la jurisprudencia, por solo mencionar eso, que es realmente encomiable. Por tanto, les deseo, como bien decía la jueza Socorro Flores, claro, siempre hay un ganador, pero yo quiero enfatizar que los dos equipos tienen, en más de un sentido, son equipos ganadores y espero que esta experiencia los lleve a seguir no solo profundizando en el conocimiento del derecho internacional, pero que esto los lleve a elegir una carrera en el derecho internacional. No tiene que ser en la Cancillería. Si lo es, qué maravilla. Nos podemos ir tranquilos a la jubilación, los miembros del jurado, de ver que hay extraordinarios reemplazos en unos años, pero hay muchas otras avenidas para trabajar en pos de la vigencia del derecho internacional. Ojalá muy pronto vengan a Europa, apenas las condiciones lo permitan, por ejemplo, a tomar el curso en la Academia de Derecho Internacional de La Haya. Me encantaría verlas en 2023, donde daré un curso en la Academia. Entonces pueden ya inscribirse para la sesión de 2023. Muchas gracias.
Gracias al embajador. Invito al consultor jurídico Alejandro Celorio a dirigirse a los equipos.
Muchas gracias, señor juez y embajador. Unas breves palabras para reconocer el esfuerzo. Sé que los equipos trabajaron mucho tiempo, muchos meses. Las rondas fueron muy reñidas, según me cuentan mis colegas de la consultoría. Y reconocer también el ánimo y la inspiración que nos generan también a las personas que estamos en la consultoría jurídica. Ver la intensidad de sus participaciones. Aprendimos mucho de ustedes. La ilusión por el derecho internacional, el ánimo de lograr la justicia internacional es algo que en la práctica burocrática lo vamos dejando de lado y queremos resolver las cosas rápido, pero escucharlas y escucharlos, sí. Permítame expresarme con la emoción de ver a cada vez más mujeres participando en el derecho internacional. Entonces, gracias por su participación tan activa, felicidades a ambos equipos. Y gracias por la gran inspiración que nos dejan. Y por favor, muchas gracias a la embajadora y a los embajadores por aceptar participar en esto.
Muchas gracias, Alejandro. No puedo ser más elocuente que mis colegas. Ya lo dijeron todo, ya hablaron muchas de las ideas que yo tenía. Quiero resaltar solamente dos cosas. La primera, reitero lo ya dicho por Alejandro. Estoy impresionado del número de mujeres que están en esta pantalla. Esto es algo inédito. Va a abrir, estoy seguro, en los años por venir, un gran camino para las mujeres en el derecho internacional. Ustedes saben que apenas hasta ahora, hasta el 2021, la Corte Penal Internacional va a tener paridad de género. No lo ha tenido en 20 años. Y hoy por hoy, la Corte Interamericana de Derechos Humanos solamente tiene una mujer, la jueza Elizabeth Odio Benito. La buena noticia es que vienen más mujeres. Para los 4 puestos de jueces que se van a elegir en esta Asamblea General de la OEA, se han presentado 7 candidaturas, 5 mujeres y 2 hombres. Yo veo con mucho optimismo que pronto la Corte Interamericana será mayoría mujeres. Y no puedo dejar de mencionar, hacer un comercial del órgano para el cual trabajo ahora, la Comisión Interamericana de Derechos Humanos, que tiene 5 comisionadas y 2 comisionados. Y eso, sin lugar a dudas, le pone un acento especial a el trabajo que realizamos. No es nada más una cuestión de paridad de género. es una cuestión de visión de la problemática de los derechos humanos y en este caso del derecho internacional. Así que realmente muchas felicidades. Segundo comentario, me hicieron sentir viejo, realmente me hicieron sentir viejo de ver tanta juventud tan bien preparada, como a mí me hubiera gustado tener ese empuje que ustedes tienen a su corta edad. Muy contento, muy optimista del futuro de México, que tanto los necesita hoy. Ya me extendí, no quería hacerlo, estoy tarde en otra reunión, no importa porque esto vale la pena. Y ahora le paso la palabra a la embajadora Socorro Flores, jueza electa de la Corte Penal Internacional, para que anuncie los premios y eso.
Muchas gracias. Pues aquí vienen los anuncios ahora de los premios. El primero es el mejor Memorial de Applicant, que va al equipo 320 de la Universidad Iberoamericana. El premio Mejor Memorial de Respondent va al equipo 409 del Centro de Investigación y Docencia Económicas. El tercer lugar al mejor orador en las rondas preliminares es para Brian Sánchez Hernández, del equipo 123 de la Universidad Nacional Autónoma de México. El segundo lugar al mejor orador en las rondas preliminares va para María Fernanda Salgado Córdoba, del equipo 409 del Centro de Investigación y Docencia Económicas. El mejor orador en las rondas preliminares va para Lorenza Urías González, del equipo 320 de la Universidad Iberoamericana. Me falta mejor orador en la final nacional. Bueno, todavía esos los van a anunciar en un momento. Y el Spirit of the Jesuit, equipo 613, Facultad de Jurisprudencia de la Universidad Autónoma de Coahuila. Muchas felicidades a todos y a todas.
Le paso la palabra ahora a Liliana Bernal para que anuncie el mejor orador u oradora en la final nacional.
Gracias, embajador. El premio al mejor orador en la final nacional es para la agente 1 del Respondent, María Fernanda Salgado Córdoba, del equipo 409 del Centro de Investigación y Docencia Económica. Y pues le devuelvo el uso de la voz, embajador Joel, para que ustedes me digan quién va a anunciar al subcampeón y campeón nacional.
Para anunciar al subcampeón nacional y al campeón nacional, invito al embajador Juan Manuel Gómez Robledo, miembro de la Comisión de Derecho Internacional, dignísimo embajador de México en Francia. And the winners are...
El subcampeón nacional es el equipo 109 de la Universidad Panamericana, Campus Aguascalientes. Muchísimas felicidades. Y el campeón nacional del Jesuit México 2021, por supuesto, el equipo 409 del Centro de Investigación y Docencia Económicas. Enhorabuena y muchísimas felicidades a todas y a todos.
Muchas gracias. Creo que damos por concluido. El champaña nos lo debemos, ¿verdad? Pero abran algo con burbujas y celebren. Nos vemos.
Muchas gracias a todos. Enhorabuena.